Good morning, everybody. My name is Nathan Darris with the Texas Department of Housing and Community Affairs. I'm in our Housing Resource Center, and I'm the data coordinator for the department. We're going to be covering written policies and procedures today. Um, just a little quick bit of housekeeping. We're going to get started at 10:05. I want to give people enough time to get in and get situated. Um, you should be able to download the handouts here. They'll come in a meeting in a chat in about 5 minutes when the meeting starts. You should be able to access those written policies and procedures slides. We will take questions throughout the day, throughout the meeting. Um, I may hold off on answering those questions until the end, just in case we are going to cover something later. But go ahead and if you have those questions, put them in the chat or in the Q&A section of the software here, whatever is easiest for you. And we'll go through and answer those questions when we get a chance. Um, and like I said, we're going to get started in about 5 minutes, well, 4 minutes now. So at 10:05 a.m., just so everybody has a chance to get in here and get situated and get their uh, audio set up. Okay, good morning, everybody. My name is Nathan Darris with the Texas Department of Housing and Community Affairs. I'm the data coordinator here in the Housing Resource Center. Um, We're going to be starting our webinar here in just a moment. I want to take a quick little poll here to see um, why you're tuning in today and what your background is. So if you give me, no, I don't have a poll today. Never mind. Right now, everybody is going to be muted today, so you won't be able to speak, even if you have your microphone on. If you have questions, go ahead and put them in the chat window. That's the easiest place for us to see them. You can also use the Q&A section. Um, there should be in the chat window and the ability to access the slides for today. As I mentioned in a previous message, I'm not sure that I can get this to work because it looks like this is a question of permissions that Microsoft has set up so that if you're not in our organization, you can't download files from our chat, apparently. There's nothing I can do about this. If you need the slides for later, please email us at fair.housing@tdhca.texas.gov. It's the email address that's on the shared screen right now. And we'll go ahead and email the slides to you. Unfortunately, I'm not going to be able to get them to you before this webinar is over. So it's going to be, you're not going to be able to just have them to follow along. That is, like I said, unfortunate that I can't get Microsoft to solve this problem. So we're just going to have to muddle through as best we can. The presentation should be about 45 minutes today. And again, if you are looking for my email address, it's on the slide right now. And I'll type it into the window, the chat window as well. It's going to take about 45 minutes to get through this presentation. There's going to be plenty of time for questions at the end. So feel free to put those questions in whenever you can. On an additional note, there's not going to be any certificates given out for this webinar. I don't have the ability to create certificates anymore. It's also already unlikely that you can use these for any kind of continuing education credits. But stick around because the information is still going to be useful. If you are here because you need housing assistance, like rental assistance or finding affordable apartments, please go ahead and use any of this contact that's on the screen, or you can just use the giant QR code that will take you to our Help for Texans website, where you can be connected with possible resources in your area. While TDHCA does not offer direct assistance, we do fund organizations around the state that do provide rental assistance, utility bill assistance, weatherization, down payment assistance, and other programs such as for her first-time home buyers using TDHCA funds. There is a video on that page that will help guide anybody looking for assistance or for reduced rent apartments and how to use the Help for Texans site. Just a quick disclaimer at the beginning here. I'm not an attorney. I cannot give legal advice. I am not giving legal advice today. TDHCA is also not able to provide legal advice to the general public. This webinar does not fulfill any continuing education credit requirements. If you need proof of attendance for any reason, there will not be certificates. I know the slide says there will. These are old. This is an old slide when I was using GoToWebinar. Go ahead and I've put the email address in chat. If you need proof of attendance for any reason, email the fair.housing@tdhca.texas.gov email address, and we will be able to get that for you to verify that you were at the webinar. If there are multiple people logged in under a single email or on a single computer, I'm not going to be able to provide that information for everybody sitting in front of that screen. There's no way for me to know how many people are sitting in front of one screen. Just whoever the individual is that's signed in, whatever email address they used. All materials and recordings of this webinar will be available after this on the TDHCA website on our YouTube channel. If you have questions, again, please put them into the chat box. After every segment or at the end, we'll try to answer all the questions. We will have plenty of time for that. And then finally, if you are here to satisfy Texas Administrative Code requirements for multifamily bond transactions or to satisfy the 10% test for housing tax credits, this training is not going to satisfy those requirements, but stick around. The information is still going to be really useful. And again, email me if you need access to training that will fulfill that 10% test or multifamily bond transaction requirement. So just a little bit of history and background about written policies and procedures here. It's not super important, but it does give a little bit of context. Basically, whatever you want to call it, written policies and procedures, tenant selection criteria, resident selection plan, it is the set of rules that TDHC or that you have that determine who you allow to live at your property. Um, Recently, back in 2020, the written policies and procedures rule was moved under Fair Housing Data Management and Reporting Division. That division has then been subsumed into the Housing Resource Center in 2023. So that is where these rules currently reside, is with the Housing Resource Center specifically. But these are basically any rules that you have that is regarding who is and is not allowed to live on your property. That is what the generic term written policies and procedures, tenant selection plan, tenant selection criteria, resident selection plan, anything like that is referring to. So what are the most basic requirements of written policies and procedures if you are a participant in TDHCA multifamily programs? Uh, Basically, the spirit of the rule is, right, an applicant should be able to look at your written policies and procedures and then be able to determine if they qualify to live at your property. Um, the written policies and procedures and any screening criteria should only attempt to screen applicants on items that are related to their ability to perform under the lease, right? These are things like paying the rent, not damaging the housing, not interfering with the rights and quiet enjoyment of other tenants. Um, that is the generically what your written policies and procedures should be covering, what you should be screening on. Our rules, this is the basic list of policies that our rules are going to require you to include in your written policies and procedures. Each one of these is going to be covered in more detail here as we move along. So we're going to start obviously with the very first one, selection criteria or screening criteria. First thing to note is that all written policies and procedures must have this exact phrase, must be word for word or verbatim. No changes to it. This sentence needs to be in there. And one of the things that people used to be able to do is, instead of it saying TDHCA's rules at the end, you could say the department's rules. The department could refer to multiple different agencies, not just TDHCA. It could be HUD, USDA, the Texas Department of Agriculture, Department of State Health Services. All of those organizations have housing or housing adjacent programs that you may be participating in, and you are beholden to their rules. So that's why we require this statement to say TDHCA's rules, to make it clear which agency you're referring to. Your written policies and procedures are basically comprised of or your screening criteria are comprised of three things: criminal background checks, rental history checks, and credit checks. Most everything falls under these three things. There may be some other small ones that are specific to a program, but in general, these are the three things that you're going to be screening for. So your written policies and procedures should say what crimes you're looking for, what services you use to search for those crimes, and how far back are you looking. Your rental history, you're searching for what rental history events are you trying to find? Is it just evictions? Is it evictions, non-payments? These are things that you're going to want to include in your rental history. Credit history, what credit scores or events are you screening on that would be disqualifying for a household that is applying at your property? So when we look at criminal histories, it is important to be very clear about what crimes or types of crimes you're looking for or looking at, which ones are disqualifying and how far back you're looking for them. TDHCA requires written policies and procedures to include those listings. So if you use, say, a third-party service, you would still need to include the list of items. Usually these services will provide you with a list of things that you can screen on, or you can select which ones you want to screen and what types of or what look back periods you use. That information needs to be in your written policies and procedures. Basically, a tenant should be able to determine based on that list whether or not their criminal history would be disqualifying. Um, you may want to consider other possible fair housing concerns here, such as whether or not screening for things like marijuana possession, uh, convictions is something that has to do with their ability to perform under the lease. Um, TDHCA, we do not enforce the Fair Housing Act in Texas. That falls under the Texas Workforce Commission Civil Rights Division. These are just things that you may want to consider when you are looking at criminal backgrounds. You may also want to consider looking at mitigating information or interventions that happen in between when the crime was committed and now. How old was the person at the time they committed the crime? If they were, say, 17, 18, and they're now 35, 45, is that still something that matters, especially if there's been no other crime in between? Services or treatments that the person has received in the interim. Does the crime have an impact on health and safety or the ability to pay? Same as with criminal screening, TDHCA, we do require you to state in your written policies and procedures what rental history events are disqualifying and what time frame or look back period you use, right? So do you have do you care about evictions only? How far back? 3 years, 5 years? Is an eviction from 10 years disqualifying? This needs to be in your rental history screening information. Again, if you use a third party screening service, you still need to include this list of items and look back periods. A yes no recommendation without that listing is not sufficient because it is still screening for those items. That yes no is just the decision based on those items. So anything that would disqualify an individual needs to be disclosed. And then credit history screening, again, this should be obvious by now. If you screen on credit history, you need to disclose in your written policies and procedures what scores or findings you're looking for and which ones are disqualifying, just like with the previous two items. This applies to all three screening types here. Is if it's not disqualifying, consider not even pulling or checking that item, right? If you don't disqualify somebody based on credit score, do you even need to pull their credit score? Probably not. So be careful about what you ask, what you pull, if it's not something that you are looking, that you're actually going to look at in terms of denying an applicant. The next thing that you need to have in your written policies and procedures is a student policy. We do not look at the specifics of what your student policy is when reviewing written policies and procedures for compliance with 10 TAC 10.802. But our compliance staff may look at them when conducting a desk or on-site reviews of the property to make sure that your student policy is in compliance with particular specific program rules, because it does change between those. Regardless, whatever your student policy is, it needs to be listed in your written policies and procedures. And if your property falls under the Housing for Older Persons Act and is limited to households that are either 55 and older or 62 and older, you must include your age limits or restrictions. That's got to be in there. And remember, up to 20% of units can uh, be non-older persons or non-senior or meet those restrictions without losing your Housing for Older Persons Act status. The next thing you need to include are going to be your occupancy policies. Prior to 2020, the occupancy policy rule allowed restrictions to be 2 persons per bedroom, but children 6 or under did not count toward that number. This is no longer the case. The age of the occupant is no longer important and no longer matters in determining the size of the household. Um, the rule here is going to be 2 persons per bedroom uh, plus 1 additional person per unit. Efficiency units that are smaller than 600 square feet do have a little bit of a carve out here, and they may restrict it to 2 persons per unit with not an additional person per bed or per, sorry, 2 per bedroom or 2 per unit here. If the efficiency is greater than 600 square feet, it still is 3 as the minimum occupancy required. That's the lowest that you can set your maximum to. And then that goes up for each number of bedrooms. But basically, there you should always have and allow at least an odd number of people per unit, unless, like I said, it's an efficiency. Um, Also, no, you cannot require separate bedrooms for non-married adults. We have seen this in occupancy policies before. Who people choose to live with is not our business. So, you could have three adults over the age of 18, and it counts the same as one adult with two over 18 with two infant children. They count the same regardless. There are a couple of exceptions here to the occupancy policy maximums, but they are very specific and they apply to your property. And if they apply to your property, you're going to need to make sure that you either document the ordinance that you are citing or the program rule that allows the exception. This is if all of the units on your property are supportive or transitional housing, and all of them are efficiencies, that is no bedrooms, a single room occupancy, you can restrict the household to being one person per unit. Again, if there are program rules or local ordinances in your area that are more restrictive than these TDHCA limits, then you can be more restrictive, but you're going to need to provide evidence of this when TDHCA reviews your written policies and procedures for compliance with 10 Tech 10.802. An occupancy policy must include a statement that a minor joining a household during a lease term will not cause the household to be in violation of the lease or occupancy policy. Um, why is this statement required? It's to preclude a situation where, for example, you know, there are a lot of different reasons it could be. Um, but I hope a compliant property doesn't need to include this statement unless the land use restriction agreement or LURA or funding source on that property requires you to accept an otherwise qualified household with a minor if a disability is present. So why would this be required in those situations, right? It's to preclude a situation where, say, a child's parents die and a grandparent takes custody of a child. The property can't issue a lease violation to them because there are now too many people in the household or because they aren't of the proper age. Um, so it also would preclude in a normal household, not in a senior property necessarily, um, would preclude issuing a lease violation to a household that adopts a child during the lease term or because they're not pregnant when they sign the lease. Um, they give birth to a child during that lease term. Giving them a lease violation is not allowable here. And that's what this rule is trying to do. Because remember, there's at least a 6 month period in any 12-month period where a person could give birth and is not pregnant or doesn't know that they're pregnant yet and isn't announcing to the world that they're pregnant yet. So just because somebody is pregnant in an application, don't ask, sorry, if somebody is pregnant at application. It's not a good idea. It's not a TDHCA rule. We don't disallow it, but pregnancy can be considered a disability, and you can't ask if an applicant has a disability. I strongly recommend not asking for it. If the household voluntarily tells you, that's one thing. I just really would recommend not asking. Your written policies and procedures also need to include your reasonable accommodation policy. And your reasonable accommodation policy needs to have some certain items. At a minimum, that policy must include information on how to request a reasonable accommodation, how transfers that are needed due to a disability or a reasonable accommodation will be addressed or prioritized, and a time frame in which you will respond to a reasonable accommodation. And this rule, or our rule, does require this time frame to be 14 days or less. So it cannot be more than 14 days. If you've taken any of my trainings before about reasonable accommodations, you should already know all of this, but responses to a reasonable accommodation request are only valid if they either grant the request, deny the request, seek clarifying information or verification about the request, or begin the interactive process to identify alternative accommodations. That is all covered under a different section of Texas Administrative Code and is a TDHCA rule. And if it is something that you need or want to learn more about, we do have additional webinars that we've conducted. We did them last month and we do them every April. Please let me know by email and we can get you a link to those recordings. There are also some things that a reasonable accommodation policy cannot do. So, and I don't want to belabor this point because I have mentioned we have a lot of training available on this topic, and I could spend a full hour on just reasonable accommodations and have done so in the past and still have leftover material to cover, but do not require a request to be made in writing. If your policies require the use of a specific form, right, you have some sort of corporate form that you use, you can ask the household to fill it out, but you cannot require them to fill it out. And if they do not want to fill out that form and their request meets the is clearly a reasonable accommodation request, fill it out for them. Have your office fill it out as they tell you what their reasonable accommodation request is. Don't make somebody who has an obvious disability provide verification of the disability. If they come into your office in a motorized wheelchair and ask you to assign them to a nearby parking spot with a ramp so they can get to the entrance of the building, you're not going to need to ask them for verification that they have a disability. You don't need to know how it happened. You don't need to know what their diagnosis is. You don't need any other piece of information that isn't necessary to processing a reasonable accommodation request. You also cannot make somebody with a disability rent an already accessible unit, whether that's a 504 unit that is already it has that are required to have certain accessibility features, or if you've already made modifications to another unit for somebody else and it has those features, you can offer those items to them, but you cannot require them to rent an already accessible unit. And you can't keep somebody from moving onto the property because you don't have an already accessible unit available. Next thing that you need in your written policies and procedures is your waitlist policy. This is maybe the most common error that I see in policies and procedures, not explaining when a waitlist will close and when it will open. Your policy needs to explain both of those things. So if I say, for instance, our waitlist closes when it reaches 15 people, does that mean that when there are fewer than 15 people on the list now, we reopen it? Well, that policy doesn't specify it. So because you also probably wouldn't want to open it up as soon as you dip below 15 people on a list, because then you're going to be constantly opening and closing and opening and closing the list. So that sentence alone isn't sufficient. More likely you would want to reopen it when it gets down to 10 people, right? So you're not constantly reopening and closing the list. So be explicit about when you open or when you close your wait list and when it will reopen. Um, if you never close your wait list, you need to state that, because it just needs to be in there. Your wait list policy must describe when it will close. If it will never close, that needs to be disclosed. If you have allowed or allowable preferences, your wait list policy does need to explain how those preferences are applied. So as an example, our home single family programs have a requirement that a subrecipient take families first come and first serve. But if after 4 applicants are selected, none of them are at or below 30% of AMI, they need to select the next household at or below 30% of AMI. That's an explanation of how a preference will be applied. So if you have a preference, you need to explain how it's being applied. What's the process? That's just one method. Whatever method the one that I gave, that's just one method. Whatever method you use, you will need to explain it and how you will prioritize. You also need to explain how you will prioritize households that need accessible units. The next item that you must have is your denied applications policy. When you deny an applicant household, you need to notify them within 7 days, and that denial notice must include the specific screening criterion that disqualified them. You also need to provide contact information for any third party whose information you use to deny the household. If you have an appeals process, you need to describe it. Some of our programs, uh, like any home developments that are owned by Chodos or units that are leased to Section 811 Project Rental Assistance households, must have an appeals process. And so that appeals process must also comply with the HUD 4350.3 handbook. And those must be in there. If you have an appeals process, it has to be described. When you deny an applicant, you also need to provide them with the TDHCA version of the HUD 5380 form. That's the occupancy rights under VAWA form, as well as the HUD 5382 form. That's the VAWA certification form. If the household is a Section 811 participant within 3 days of a denial, you need to contact TDHCA's Section 811 point of contact and provide them with the written notice that will be or was sent to the applicant. This is pretty self-explanatory here, but you have to keep a log of denied applications and keep basic demographic information about the applicants. What, if any, rental assistance they had and the specific reason for the denial. TDHCA can and will request these items from time to time. You also, in your policies and procedures, must allow a person to submit an application at minimum either in person or by mail. Other options can be utilized. Those are just the minimums, but mail and in person do have to be included. And there can be no preferential treatment or placement for specific application methods. You cannot have a preference for people who apply in person and have and prioritize them over people who apply by mail, apply online, apply by email if those are things that you allow. It should be obvious that you also cannot deny an applicant because they applied either by mail or in person. If it is an application method that you accept, you can't deny an application because they didn't use your preferred method. The next policy that you need is your non-renewal or termination policies. If you serve a notice of non-renewal or termination, you need to consult the rules for your specific programs to make sure they are compliant. Each program has its own rules about this. At a minimum, you must include HUD 5382 and TDHCA's version of the HUD 5380, just like an application denial. You also need to include information on how a person can request a reasonable accommodation in relation to the notice to terminate or notice of non-renewal. If you have an appeals process, describe the appeals process. Some programs, as we mentioned, require an appeals process. You must include a reason for the termination or non-renewal. I say that again. You must include any reason for the termination or non-renewal. You cannot give a notice to terminate or notice of non-renewal that does not give a reason. Also, if it is a notice of non-renewal, your lease is ending and we just don't want to renew is not a reason. And so don't use that one. End of lease term and we don't want to renew is not a sufficient reason to not renew. This is less common, household designation policy. If you choose to have a policy about when you will change household income designations, you need to include it in your written policies and procedures. If you do not include this in your written policies and procedures, you cannot change a household's designation outside of when a household is certified or recertified. So if you're not going to change it, if you want to change a household designation policy at other times, you need to have that policy in your written policies and procedures. So what about what you can't do in a written policy and procedures? We've talked a lot about what has to be in there. Let's talk about what can't be in there. Most of these have already kind of been covered, but a quick reminder, you cannot deny a household simply because they receive some form of rental assistance. If you are a TDHCA monitored property, or receive any kind of federal funds through TDHCA or tax credits, right? You cannot deny a household because they have a Section 8 housing choice voucher, an emergency housing voucher, any other kind of tenant-based rental assistance. You also cannot deny an applicant household because they have VAWA protections. Now, that doesn't mean that you have to accept a household just because they have VAWA protections. They still need to meet basic income and eligibility and that kind of stuff. But if you have a household that applies, they meet all of your income requirements and all of your other qualifications, and they just happen to have VAWA protections as well, not a valid reason to deny the household. You also cannot make a person with a disability rent an already accessible unit. You also cannot deny a household because you don't have any accessible units available. You also cannot retroactively apply screening criteria to an existing household. And then finally, you cannot include preferences that are not approved by TDHCA and that are not in your land use restriction agreement or contract. If you have preferences that are in your policies and procedures and they're not in your land use restriction agreement or contract, you are going to have to either get rid of the preference in written policies and procedures and not have them, or you're going to have to amend your LURA or contract, which is costly. So TDHCA has created a handful of new tools recently, including a checklist that will help you identify some of the major areas of non-compliance that we see in our reviews. Most everything that was covered today is covered in this checklist. So you can use this checklist. It is anonymous. There is a section in there that asks for a CMTS ID number. That is optional, and I only included it there for people who may want to print the results out for their own records. Um, I do not ever go in and check answers. I do not check for CMTS IDs. I do not initiate reviews based on those responses. This is just a tool that you can use to help make sure in between reviews, your written policies and procedures are compliant with our rules. Um, and just because the checklist doesn't identify a problem, that is not a guarantee that the plan is not full. That's not a guarantee that the plan is fully compliant. It is simply a tool to help you find and remove the most common errors and items of non-compliance. You can find that tool on our Fair Housing Tools page, or you can use the QR code here directly to go to that checklist so you can bookmark it there. Um, and it has been very useful. There have been several people who have told me that it has helped them. I have noticed that it has helped when people have told me they've used the tool and then submitted the written policies and procedures for review. It tends to be better and not have as much identified non-compliance. If you have any questions, and I'm going to give you everybody a chance to write this down, um, we're also going to take a look at any questions that may have come in. I haven't seen any yet, but this is a good time. If you have questions, please send them. But if you have any, need to contact us for any reason, these are our contact points of contact and our contact information. If it's related to fair housing or written policies and procedures, affirmative marketing, reasonable accommodations, go ahead and use that fair.housing@tdhca.texas.gov email. For any other basic or general queries, you can use info@tdhca.texas.gov. And we also have a couple different phone numbers that you can use, or you can send us old-fashioned snail mail if you really wanted to. Um, Again, if you need housing assistance, please contact us this way via info@tdhca.texas.gov, or you can visit the Help for Texans website. The QR code here, it's giant. It will take you directly to Help for Texans, and a video on that page will help guide anybody who is looking for housing assistance or for reduced rent apartments. This is also a good time to point out if you have tenants who may need housing assistance. This is a good place to send them to. If there is rental assistance available via a TDHCA funded subrecipient, they can find it here. So it doesn't hurt to work with your tenants when they are having trouble paying. It's always better to have a paying tenant than a non-paying tenant. So if they need a little bit of assistance, this is the place to send them to. I have still not seen any questions come in via the chat box. Here we go. One question. A resident requested a vision or hearing sensory adapted unit due to being blind and moved in, and now they have submitted a reasonable accommodation or modification request to disable the doorbell and strobes. Is this acceptable to disable them? Yes, it is. This is more about reasonable accommodations and modifications, but the answer is yes. Um, a household with a disability may believe and have reason to believe that they have need for a specific type of um, accessibility feature, whether that be the strobing um, alarms or doorbells. Um, they may also not need it for their doorbell. Specifically, they might only need visual and auditory alarms for a fire alarm or smoke detector. So, yeah, you can disable the strobe and visible doorbell and still be compliant with our rules. When that household leaves, you need to put it back in if that is one of your the 2% set aside units by section 504 for hearing and visual accessibility. But while the household that needs the unit is there, you can make that modification. It's not going to count against you. What if a property is 62 plus or disabled? An applicant is disabled and has a 4-year-old with no disability. Must we process? You need to consult your land use restriction agreement or your contract to see what is required. Some programs would require you to accept this household. Other programs do not require it. So you need to look and see what your land use restriction agreement says. Unfortunately, there's not a singular answer I can give you because it is dependent upon what is in your contract slash land use restriction agreement. A resident has requested a reasonable accommodation for a second bedroom based on needing somewhere to store a wheelchair. However, the size of the 1-bedroom unit is large enough to accommodate their furniture and the wheelchair without blocking any access to the interior of the unit. Any suggestions? I should have known that a written policies and procedures webinar would get more questions about reasonable accommodations. So the answer here is you do have the ability to request verification that there is a disability related need for the requested accommodation. So, is there a need for the second bedroom specifically, or if there is a just a need for more space to store the medical equipment itself? This is something that a household, right? This is never going to be a readily apparent thing. You don't know what the size requirements are, what their furniture setup is going to be. So this is something that you can request documentation from the household, from a medical professional or a qualified third party that is in a position to know about the individual's disability and disability related needs. That usually takes the form of a medical professional, but it could be some kind of service professional. Um, Social workers quite often, if this person has a medical service provider, this medical service provider oftentimes will be in that position to know. I also would then recommend that you go ahead and send me an email at the fair.housing. I'll go ahead and reply to that one specifically. Um, at the fair.housing inbox uh, so that we can get you in touch with more training that we have specifically on that topic. So I'm typing that in right now. Give me 1 second. I apologize for hearing typing noises. Okay. The follow-up here is that the medical provider stated that the second bedroom is to store the wheelchair. No other medical equipment is in place. Yes, the answer still kind of remains the same. It's going to be dependent upon what the medical provider says is necessary. What if we have no available units for a tenant to transfer to? Should we allow them to break the lease with no penalty? Uh, Kaylin, I think I'm saying your name correctly. I'm going to make a couple of assumptions. Correct me if I am wrong in the chat here. But I am assuming that you are talking about a transfer for a household that has a disability related need to move to, say, a first floor unit. Yeah, okay. So yes, that you have verified that is correct. So the answer is yes. if you do not have an available unit for a tenant to transfer to and they need that transfer for a medical reason, for a disability related need, you can allow them to break the lease with no penalty. That is an acceptable option. Yes, absolutely. All right. I think that I have gotten, let me check the Q&A section really quickly again. There are a couple more. Wonderful. If we do not have student rules, are we required to state that in the written policies and procedures, or is it okay to not list a student policy? Celine, I am assuming that you are you have a TDHCA monitored property, correct? If that is correct, then you do need to have a student policy of some sort because you need to be able to determine whether or not a student head of household is qualified for the program. So yeah, you're going to want to make sure that you have a student policy. It's not going to be okay to not have a student policy. So I would consult you say you're with it's an NHTF funded property. Yeah, you're going to want to see what the NHTF specific rules are on what your policy needs to be. You can also email Kara. Thank you so much. Kara Poli is on this today as well. And she has put the email address that you're going to want to contact if you have a student requirement to find out if you have a student requirement or not. So Celine, in the chat, you're going to want to go ahead and email Kara at that email address that she provided. Another question. If disabled, I'm assuming, Patricia, this is a follow-up to if you remove an item from a Section 504 unit for somebody who has a disability related need to do so. Will it cause issues during the TDHCA, Inspire, and final construction inspections? The answer is no, it shouldn't. It might cause a little bit up front, but if you explain to us during, right, so you'll get an Inspire inspection report. If you'll explain to us when you get that inspection report, um, then uh, you're going to be able to explain in your response back to TDHCA that it's due to a reasonable accommodation. That is an acceptable reason for it to not be there. In general, unless it's like a massive health and safety issue, um, a reasonable accommodation is an acceptable reason to have something that is out of compliance with an Inspire inspection, generally speaking. Can we limit the occupancy to only 2 per bedroom, not 2 per bedroom plus 1? No, unless you have unless the unit is under 600 square feet and it is an efficiency studio, right? Not a 1 bedroom, but a 0 bedroom unit. It still needs to be 2 per bedroom plus 1 per unit. So a 1 bedroom unit will always need to be at 3. A 2 bedroom unit will always need to be at minimum 5 that you allow, unless there is a local ordinance or program rule that requires it to be more restrictive. I believe that is all of the questions that we have received so far. I'm going to slow play my closing just in case anybody is still typing them. I'm thinking, though, that we are done for today. So again, if you have questions, I'll put the contact information back up. Please feel free to email us and we will get an answer to you. And also, as Kara mentioned in her message, and I'm going to put this in the chat as well, just so that it's out there by itself. If you have questions about your program specific requirements, about your land use restriction agreement, about your contract specifically, You can also email multifamily compliance at tdhca.texas.gov, and they will be able to assist you with finding the answer. Um, Without further ado, I believe that we are done for today. So thank you all for joining us. As if you need the slides, like I said, email us at fair.housing@tdhca.texas.gov, and we will send those to you. If you need a verification that you attended the webinar, you can also email us there as well. Thank you all for joining, and enjoy the rest of your week.